In today's video, we discuss the impact of the California Privacy Rights Act, or CPRA, which comes into effect on January 1, 2023, on the information governance obligations of businesses subject to the Act.
Our main focus will be the CPRA storage rights limitation, which it takes from Article 5.1(e) of the European Union General Data Protection Regulation, commonly known as the GDPR, and how that obligation impacts businesses' record-keeping and data disposition obligations. Let's go. On November 3, 2020, California voters approved the California Privacy Rights Act by a wide margin. Like the GDPR, the CPRA imposes a storage limitation requirement, effectively prohibiting businesses subject to the law from keeping records containing personal data in a form that permits identification of data subjects for longer than necessary for the purposes for which the personal data are processed.
The specific storage limitation language of the CPRA provides that a business that controls the collection of consumers' personal information shall, at or before the point of collection, inform consumers as to the length of time the business intends to retain each category of personal information, or if that is not possible, the criteria used to determine such period.
The law also specifically prohibits businesses from retaining a consumer's personal information or sensitive personal information for each disclosed purpose for which the personal information was collected for longer than is reasonably necessary for that disclosed purpose.
On a practical level, this means that as of January 1, 2023, the date on which the law comes into effect, that businesses subject to the law will need to a. determine how long they plan to retain each category of personal information they collect from California consumers and update their notices at collection to include that time period, and b. implement policies and procedures to ensure the personal information is kept for no longer than necessary to accomplish the purposes for which it was collected.
This limitation means that businesses subject to the CPRA storage limitation principle are effectively barred from hoarding data in perpetuity. In fact, like the GDPR, businesses subject to the CPRA face potentially significant compliance risks and fines if they unnecessarily hold on to data, especially personal data, beyond its useful life.
As a result, to comply with the CPRA, businesses will need to implement effective records management programs that mandate the purging of personal data following the expiration of its useful life or mandatory retention period. And laws like the GDPR and the CPRA, which directly impose specific retention and related notice obligations, raise the stakes significantly.
At Knowledge Preservation, we aim to provide businesses with effective and defensible information governance guidance that enable them to navigate the data life cycle. Knowing when, how, and how long to keep data is no longer just good practice, but has become necessary from both a general regulatory and privacy protection perspective. And, failing to defensibly dispose of data can lead to fines, negative publicity, and other adverse events. Contact us today to discuss how we can help you put the pieces together to create compliant information governance.